Hello everyone, welcome back to DPIIT-IPRCHAIR IIT Roorkee YouTube channel. In today's video, we will be diving into a very important case, that is Dabur India Limited versus Amit Jain 2009. It's all about the battle of hair oil packaging design under Design Act 2000. So this case revolves around the issues of design infringement, estoppel, and novelty in the product packaging under the Design Act 2000. And the section 11, 19, and 22 applied in this case. As you can see the slide with all the description of the case, like judgment date, the appellant and the respondent, and the judges. So brief of the case is Dabur India, a well-known FMCG brand who had registered the design of its bottle and caps used for its product under the Design Act. In 2005, Dabur discovered that a company owned by Amit Jain was using bottles and caps that were very similar in appearance. Later, the Dabur had earlier filed a suit and settled it with an undertaking by the respondent not to copy the designs. However, the respondent resumed using similar design, which led to this new legal action. So the breach of undertaking was in 2007, where Dabur again found similar bottles in the market. The same party, now operating under MSVN Cosmetics, had resumed selling hair oil in bottles that Dabur claimed were fraudulent imitation. This led to a second legal action and the filing of an appeal after the initial suit was dismissed. And the appellant arguments were like Dabur argued they had exclusive right under Section 11. The imitation was deliberate and deceptive, violating Section 22. Prior cases confirm that exact similarity is not required, even a planned imitation is actionable. The earlier undertaking should act as an estoppel. Thereafter, respondent argued and he defensed that the current design was not the same as the earlier one. Dabur's design lacked novelty and was common in the market. The bottle design was already published in the US, making it non-exclusive. And here are the issues: whether earlier undertaking by the respondent act as an estoppel, whether the bottles and the caps were used deceptively similar to Dabur's, then whether Dabur's design had sufficient novelty to deserve the registration. So talking about first issue, estoppel from earlier undertakings, Dabur argued that Amit Jain had previously agreed in court not to use similar designs and that promise binds him legally. This is an principle of estoppel, which stops the party from going back on their words. The court agreed, stating that once such an undertaking is given, the same party cannot violate it by using similar design again. This principle was supported by the case of Shailendra Narayan Bhanja, Dio versus State of Odisha. Then coming with the second issue, are the design deceptively similar? Even if not identical, are the designs deceptively similar to mislead customers? The court noted that exact sameness is not necessary. Even planned imitation with slight difference can lead to confusion and qualifies an infringement. It relied on the judgment in Jain Electricals versus President Electricals and Dunlop Rubber Company Limited versus Golf Ball Development Limited. After comparing both bottles and cap physically, the court found that the respondent's design was indeed deceptively similar. Then coming over the third issue, the respondent claimed Dabur's design lacked novelty and had already been published by the US Patent Office. However, the court ruled that Dabur's design had sufficient originality and was unique enough for registration under the Indian law. So the court emphasized that foreign publication does not automatically invalidate Indian registration, and it relied on the case of Gopal Glass Work Limited versus Assistant Controller of Patent and Design to support this. So the main provision under the Design Act 2000 discussed under this case were Section 11. which says copyright on the registered design. Section 19, cancellation of registration. Section 22, piracy of registered design. These section protects registered design, allow cancellation on valid grounds, and penalize unauthorized imitation. So the judgment of the court was in favor of Dabur India Limited, and court decided that the earlier undertaking binds the respondent. It creates estoppel for them. The bottles and cap were deceptively similar and thus infringing. The Dabur design was novel enough to justify legal protection, and foreign registration do not cancel out India's right. So, with in this case, the court ordered an injunction restraining the respondent from using the infringing design and imposed a fine of rupees 20,000. So that was the case of Dabur India versus Amit Jain. So these are the references, and this case is a strong reminder of power of registered design and seriously who are violating, and this is undertaking for those. Thanks for watching and stay tuned with us for more legal judgments.